anybody because today's a different day. But everybody, Chuck Cook, Greg Siskin, Aaron Hall, on our new day, Wednesday, thanks to my teaching schedule. Thank you guys for accommodating me to Wednesdays at noon. But Greg, you have to head off in a second.
Sorry about that. There's not that much going on. I'm also on my laptop, so I don't have the data on the 601A stuff available. Although I did check it yesterday, and it had shown almost no change over the last week. So we're back in a stall situation again, as far as they're not even moving cases right now. No new approvals.
No new approvals, no new action, nothing happened in the last week. I do monitor our Facebook group, and there was somebody mentioned somebody got approved, but I think it was in a different group. And again, we know
as of yesterday, it wasn't one of our plaintiffs.
No, it wasn't one of our plaintiffs. So, but just to give the update on the status of the case, unsurprisingly, the judge has done nothing. Unless I missed something, Aaron. I didn't miss anything, did I?
No.
So I would imagine the government is as anxious as we are to get a resolution moving forward here on this case, because just sitting on this is getting old. And no, you cannot file a lawsuit against the judge to make the judge file a case fast, adjudicate a case faster.
Which applies to the Go case also, which is going to be the case.
We are now
Jesse is having issues as far as being able to get in here. He has shown up in the comments.
Oh,
maybe he doesn't. Maybe we need to text him the link again.
Oh, how do I get in here? Well,
I'll send him the link.
Send him the link, and hopefully he can click in. He's on our listserv that gets our link. That's hilarious. How do I get in here? I love Jesse. But the Go litigation is out 11 months. If I look back at my 35 years of filing appeals, I probably had one or two cases that took this long. I mean, it does happen, but they're rare.
Jesse, I just texted you the link.
So hopefully just to get in here. But as far as 601A, the litigation with Ayla, it's pending. I did a podcast this morning, Aaron and Greg. The title of the podcast is "The USCIS is Lying to You," and it was about the processing times. And I did kind of a deep dive. Including on a 618.
That could apply to a lot of different things other than
it's good, but they're lying to you about processing times. And I went through all of them. I mean, it's just crazy. Things like I-90s, which I gave an example. So I got my birthday's coming up in October, and my driver's license after 10 years expires. I got an email yesterday from the Georgia Department of Driver Services. Hey, your driver's license is expiring. You want to renew it? Click this button. Click the button. Is this information correct? Do you want us to mail it to you? That's an extra $5 besides the $27. Thank you very much. Took 37 seconds, push a button, and I expect my new card tomorrow in the mail. Immigration, you can go online, fill out their form, pay them $540, and in 20 months, for 80% of the people, they might send you a card. Now, here's one of the big lies that I saw, by the way, on the I-90. They don't have separate drop downs for new and replacement. So they combine them both. And we know from our own clients that new cards come pretty quickly. New cards have been coming, client enters the United States, or they get approved in the local office. Those cards have been coming bing, bang, boom. So why is USCIS combining them into one number? Because it's a lie. It's just a lie. The whole thing's a lie. Sorry, I got really caught up in that today. I'm still angry about it. But the 601s are at 44 and a half months, have not moved. We know that's a lie because 44 and a half months is from today would take us back to, do the math in my head, that would be April of 2019, right? There's still cases pending from April 2019. Not ours, but there are. So, I mean, it's just the whole thing just sucks. There you go. So that's 601. Aaron, any update on the 601 litigation?
Yeah, nothing too substantive, but they did submit a notice of supplemental authority on August 11th. That is a case that they submitted that was decided in Southern District of Florida. And it found no subject matter jurisdiction and said that they would have ruled against them on the track factors as well. So they dismissed this person's case. The arguments and the analysis, we haven't seen the underlying briefing, but the issues are similar to the issues in our case. I think it's a bad decision, and I hope that our judge.
It's a terrible decision, and I hope that person isn't dumb enough to appeal to the 11th Circuit, because bad facts make bad law, and I don't think the facts in that case were that bad. Actually, it was not a 601 case, though, was it, Aaron?
That one was a.
Wasn't it a 526 case?
No, it's a 601 or a 601A.
I think it was a 618.
Yeah, it's not a good decision. Not a good decision for us, but it's just not a good decision at all.
Well, I mean, they do a number. I mean, I'll just give one example of why it's not a good decision and why. And these are things that we've addressed. It's not that the court hasn't seen these in the briefing, but when in one of the factors in deciding if it's an unreasonable delay under these things called the track factors is whether there is a rule of reason, and the court just accepts that they do first in and first out, and then
which is not true.
Which is not true. But even if it is true, even if they did that perfectly, that's not the end of the analysis. It's one factor in a number of factors that the courts need to look at. And then another factor, the court looked to whether there is any indication or timetable that Congress has expressed saying when these should be adjudicated. And they say because this indication that is in statute saying that there's an expectation that immigration benefits get decided within 180 days, because it's not mandatory, that it doesn't apply. Well, that's not true, because the factor is indication or timetable, and the court just glosses over that. So it's a bad decision. And it's not that our briefing doesn't address all of that. It's all there, and we're hopeful that our court will see through it. But when people are litigating cases all over the country, there's going to be some bad decisions from judges all over the country, and so it's not that it makes me nervous or makes me panic. It's just something that they saw, that they submitted, that the court has now. It is. Well,
Aaron, it also might be that maybe the lawyers that are doing some of these cases don't quite have the experience with and the 35,000 foot view that we have from the number of cases we've done to really properly address this. I mean, there are a lot of cases being filed that should not be filed. Shouldn't be.
Yeah,
they just shouldn't
be. I mean, I haven't
filed by people that shouldn't be filing them.
Like I said, I haven't looked at the briefing or even the lawyer, so it could have been that they did a great job and they just got a bad decision from a judge who. So I don't know, but yeah, that's possible.
But there's just a lot of stuff going on out there that when the government wins, because the government's making the same argument in every case, all over the country. They're submitting the same briefs in every case, and that's like throwing mud against the wall. Something's going to stick. And the reality is the cases that you might win are taking a lot longer than the cases you might lose. And that to me is one of the indications of why a case is taking so long, is that it's helpful because the judge is writing a decision that we prevail on. That's my hope. But it's just very frustrating to see these cases come down, because when the government submits a case like that, we don't have a right to say, well, judge, that case sucks and here's why. We're not allowed to do that, unfortunately. And the government doesn't comment. The government just says, here's a brief. Here, at least that's what they should say. Here's you should look at this. But they don't get to argue it either. And that's the problem, because if there's no oral argument, then we don't get to explain why that case is different or why it's a bad case. And that, it's obviously a concern as well.
Now, if
Jesse, welcome. Jesse, go on, Aaron. Well,
I was just going to say that if the court finds a new case, the supplemental authority is a game changer. It could be a game changer. A court can and often does order supplemental briefing to say, what do you think about this? So it's not that it won't be addressed, and if it's that big a deal, it could be addressed. But there, like you say, we don't get to do a response brief just on a notice of supplemental authority.
Jesse, you're looking good. And where's the hoodie?
Yeah, listen, I'm a professional now. You know, I don't know if you've heard, but I graduated from law school. I got a law license now. First time on. No, I will say though, I mean, so we've seen this happen before. I mean, DOJ, they win a lot of lawsuits, they get emboldened, they get confident, and then it goes up to an appellate court, and appellate court actually reads the Administrative Procedure Act and says, wait a minute, time out. I don't think this is actually how it's done, because district courts have an incentive to get rid of cases, right? They don't want to be busy and, oh my God. The appellate courts are like, whoa. Now it's my problem. Hold on, time out. And I think that's where this next, this is where it's going to go. It's already there with the 601As. It's not our case, but we have great lawyers working on the appellate cases. We'll be filing amicus, meaning briefs to help the court make a good decision. And it's extremely important. And don't forget, Gomez and Go are really, at the end of the day, a similar story. Can the government shut down a category of a visa and turn their backs towards what Congress said should fly? And, so that decision has so much, we talk about these things and connecting the dots. It has so many, that decision on appeal is going to be pretty important for multiple, not only the plaintiffs, but for, lawsuits now that have to contest with the government's idea that when we decide to shut down, we're making a decision that no one can review, because that, in fact, is a judgment, right? We've made a judgment to not do anything. So you've paid us. We don't care. That is a judgment, and no one can review that. I think that's going to have, I really believe, even the most, I don't even care what the panel is. I think judges are going to have a really tough problem with that argument. I
agree.
Yeah. I think even SCOTUS would. Like, Justice Gorsuch would never in a million years think that would fly. Like, hold on. You're saying that you're making a judgment by not making a judgment?
I don't see Roberts agreeing with that.
No.
Or even Kavanaugh. I mean, I really don't. I don't see how they can just let the administrative state. Basically, that's letting the administrative state have complete control.
Yeah, the only one who's going to agree with that
All right,
would be.
you heading out, Greg? Greg's heading out.
Yeah, sorry. Thanks.
All right.
All right.
Yeah, no way those three justices allow the administrative state to control everything.
No, and it's really, I mean, it is a wrong read. I mean, that's the ultimately, I think at the end of the day, that's these decisions, we're losing some battles, but I think the war is very far from over.
Yeah, I agree. Jesse, it was good to have you. Sorry for any confusion on getting you on live with us.
No.
But next time, check your email. Just
yeah, I should do that. I should, know what? Yeah, go ahead.
Well, I was just going to say, we talked earlier, it's 11 months. It's been 11 months since we had oral argument in these cases. And the couple of cases that I've had take this long ended up well for my clients. And I just have to believe that there's just a struggle trying to get to the right answer. And the right answer clearly is you can't just not work. You just can't do that.
Yeah.
Plus, the DC circuit is the premier circuit in the country. So,
yeah,
I
bet that, I mean, again, it's for those who are on the other end of this waiting in their home countries for the chance to get a visa. But at the end of the day, this decision is so important in many ways about executive authority that it's probably best if we do have just an incredible decision that maybe cannot be appealed because it's so tight. Yeah. And maybe, again, we can't forget. I mean, how many cases are in this? 5?
Oh, yeah. There was I think there's 6. But think about this. Who is writing the decision, right? Each of these judges believe that they're the next pick to the Supreme Court. They believe that is who is on the DC circuit. I can be the next SCOTUS pick by Biden or the next president. So I have to write a decision that my future colleagues, I think majority-wise would agree with.
Well, I mean, I know it's not Henderson. No,
Henderson's not going to be the SCOTUS. But
it better not be Henderson.
The other two for sure.
Yeah, no, I mean, I actually have briefs filed in my name where Katsas is the acting attorney general. So of the United States. He served briefly, in that
very
capacity.
briefly.
Yeah. Yep. So he's no joke, but I think the chief judge gets the first pick, right? That's one of the benefits. So
Yep.
if he hands the ball off, maybe it's like, hey, you can have this, but you're not gonna, don't go too hard, because Katsas, I think, reluctantly was for our side.
I agree. I agree. That's the impression I got. Now, you can't go off of impressions in court, but that's just the impression I got as well.
I can't even remember the oral argument.
Oh, I remember vividly.
Hey, I
It's
just
been so long.
remember looking out in the field, and I thought I was watching Chuck with my two kids, and I said, "Listen, that's Joe Namath up there arguing." I'm telling you, that's the only thing I remember. That I had a front row seat to Joe Namath, and no one.
Oh,
will
you're a
tell
very
me
funny guy.
But
That was a lot of fun.
I'm envisioning like a fractured 90-page decision, because there's so many plaintiff groups and so many arguments and there could be concurrences or dissents. I think honestly, it's just a big project to put it together.
It never should have been all together, personally. But
And I think what you're going to have is I think Katsas really and Srinivasan, they all met on the idea of, I need to get into what an admission versus an entry versus an issuance is. And that was left kind of open by Trump v. Hawaii, right? Yeah. But giving meaning to those words is so important.
Well, maybe we can address the Flutie doctrine.
Maybe. They tried to by statute. I mean, listen, but I think it should always be said, though, that this administration could have done right by these visa holders
and done it. Just
and they could have just taken action. So, I mean, at the end of the day, this falls on the seat of the administration too.
I agree.
But again, it goes back to kind of one of the things I've really been spending a lot of time on is, the government racks up a lot of wins sometimes. They get really confident, and then they get an unbelievably bad decision. Like I could see this, happening with consular non-reviewability. They just got dinged down in Arkansas.
They got dinged on that already in California.
Yeah. Hey, Sabrina Damas and Eric Lee strike again. Don't want to tangle with them. But again, there's cases from the 9th and DC now opposed. Those are going up. They want that 9th Circuit. And, I don't think it goes with everything we've been saying about how much authority does the executive branch have to shut down?
Well, you've got that whole supreme executive kind of thing. Hey, I do want to address one last thing before we go to questions. EB5 case has settled. We got a great deal from the government. This is what happens when you beat back a motion to dismiss or a summary judgment, and they've got to produce discovery. In this case, you may recall the government answered. They did not file a motion to dismiss. They answered, and then they filed a motion for summary judgment. And then I moved for Rule 56D discovery, saying, Judge, I can't answer this because of X. And the judge said, well, you don't, because X, Y, Z. So you don't need X, you don't need Z, but I'll give you a Y. And she gave them 90 days to give me Y. And the day after they gave us Y, they changed how they adjudicate EB5 cases to comply with what we were demanding in our lawsuit. So each of our plaintiffs will be adjudicated within 120 days. 120 days from last Wednesday, I think. I'll have to take a look at it. So sometime in November. And if there's a request for evidence, the government has 45 days to respond to and make an adjudication on the RFE. So, that's the reality is, as I told the plaintiffs, if we had kept fighting, so that I would have to file a motion for summary judgment, blah, 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 we would not have a decision in 120 days. There was zero chance that was going to happen. So this is a win-win for us, and it got us some great discovery. I don't know if you were able to use it at all, Jesse, in your litigation, but it's very interesting stuff.
But so again, we're going to connect some more dots, because everybody got their butts kicked on 526 delays for the most part, including me. And but the litigation wouldn't stop. No, people just refused to agree with that notion that 6 years is cool and that you can just sit on my case and do nothing. And through your efforts to get discovery, and we took an appeal and had I thought, a good argument in another companion case. They actually took action in my case. So my appeal is going to be done. Yeah, it's going to probably, and so we won't get that appellate decision, unfortunately or fortunately. And, we are going to have, I've seen actually in other cases I had pending where they've now sped up processing. I think that they've gotten the message. Because
especially if they're not Indian and Chinese, there's literally, they have no defense now, especially since they announced that their new rule of reason is truly visa availability. There is literally no excuse.
Well, and the other thing too is it just goes to show you that litigation, can affect change through policy, because I think, everyone, they were staring, I think DOJ was saying, really hate these delay lawsuits. Like, this sucks. Like, can you do anything about it? And they said, maybe there's a better way for us to actually handle 526s and, and
like work on those cases where people can actually get green cards in a reasonable period of time.
Now, I will say though, what we're seeing is, and this has been something I've been talking about for 2 years, and I'm sure you're seeing it too, Chuck. Well, maybe not you because you don't lose, but I've seen delays go to denials. Seen a lot more denials.
Well, yeah, and actually, if you look at, part of the problem though, Jesse, is there have been several regional center failures, and it's very easy to deny those cases. The regional center failed. It's a fraud. It's gone. You're denied. Have a nice day. So they did nothing on any EB5 regional centers for years, and all of a sudden a couple fail. All right, well, you're toast, and you might as well get rid of those 30, 50, 100 cases. But now that we have the discovery on how many were denied, we can look at the actual stats. Yeah, it's about 20% in the last year have been denied, but it's not a huge number. It's like 200 cases. It's not a huge number, and that easily can be accounted for most people for a bad regional center, or just for source of funds where you're going to get a lot of these denials.
That's where it is. It's a source of funds. They're like, hey, your dad gave you money. I want to trace back 200 years, and I want to see, I want to see the parchment where
it's a legitimate request. I mean, it's a legitimate request. When I do EB5s, I tell people, look, show me the money. Where'd you get it? I mean, give me every tax return until you had $1 in your bank account, and from your babysitting job to get you to the $1 million. I need to see it all. If you don't have it, maybe EB5 is not the visa for you. So I think that it's one of the things I saw in the discovery though is powerful. There are about 13,000 pending EB5s, and 8 of those are India and China. The rest, literally, almost everybody else could get a green card in the next 12 months. Almost everybody else, because there's somewhere around 8,000 green cards available. So maybe 2/3 of them, if immigration would do their job on these other cases. So we'll see. All right, let's take a look here on the comments. Let's see. Messina, it's August. Yes, 11 months. We're talking about this. Waleed, good to see you. What happens in the Gomez case is not an issue before 9/16. Nothing. There's not like a magical year. Wouldn't that be great? Could Congress pass a law, Jesse, that every appeal must be decided in 12 months?
Yeah,
they could. Are they going to?
No.
Well, only those appeals that are funded by the Koch brothers get approved in 12. No, sorry, wait a second. That's only at SCOTUS. I don't think USCIS goes in order reviewing 601. We don't.
Okay.
But no kidding. Well, and here's the deal. Why? Well, they have 300 people working remotely. They didn't, they don't just sit down today. They get on a conference call and say, today we're working on those cases filed on January 3rd between 11 and 12 p.m. They give people, here's 30 cases, here's 40 cases. It's not in order. It can't be, but it's not even close to that. All right. Nick could be our last. What is the government reply to the response to the motion happened on August 11, 601A? What is the government reply to the response to? Oh, he's asking about the government reply, which was a standard government, plaintiffs suck, their argument sucks, we're the greatest.
Yeah, it shouldn't be stayed,
Should be stayed, blah, blah, blah.
It should be stayed. But and again, at the end of the day, the Ninth Circuit and Fourth Circuit are gonna
Going to
tell
make
us
a decision here.
They're gonna tell us what's going on. Yeah, for sure. And
I would think that this judge would want to go out in a blaze of glory as he celebrates his 89th birthday.
totally.
If it was me, I would approve everything. Burn the government down, baby. Everybody gets a visa. You get a visa.
I would just be like, if it does, it's a really good point. I mean, I know it's kind of tongue in cheek, but it's a really good point that if the judge disagreed and thought he had something smart to say, he should say it so that the Ninth Circuit has it for review, and the Fourth Circuit. Yeah. I mean, if he reads it differently, he should say so, because he would speak louder than any amicus brief.
Well, the thing is, too, he likely has more and better briefing on this issue than any other district court judge in the United States. I would dare say he is the most, at this point, the most informed judge on the 601A issue in the United States.
Yeah.
So Hayes, Nick, we just talked about their response was the judge should stay the case because we say so. That's basically what they said. It's really a nothing burger response. We anticipated everything they were going to say. It's in our response, and now it's been noted. So we wait.
Our response. I mean, I know. We had Zach and Leslie and so many great attorneys who just kicked. They honestly kicked ass on them. That was like one of the better.
Oh, it's a great brief. It is if necessary, it's our Ninth Circuit brief.
It's awesome. I mean, I loved reading it and working on it. To the extent I changed a comma here or an apostrophe there. I mean, I love doing that. Yeah, but no. I mean, listen. Like I said, I mean, I think. I say this all the time. Litigation, you have someone on the other side. It's like it's an adversarial system, so we cannot make predictions about how it's going to go. We can only defend our side. It's like taking care of your own business. So we're doing that.
We got our business taken care of. You do you, and it will do us. We'll see you guys next Wednesday, which will be our new time for our update.
Hump day.
Thank you guys for accommodating me, and Jesse will get on. My law school class normally goes from 10 to 11:30, so I can be back on a Tuesday at noon. But this year they changed it 10:30 to 12:15, and I can't get back from Emory Law School in time to do the podcast to do this. So, thank you very much. Maybe you guys could guest lecture my class one time. That'd be
fun. Awesome. Jesse and Chuck, hold on for 1 second after we go off. All right.
All right. See you guys later. Have a great week.
All right.